when we did the agenda for when we did the Rhode Island Coalition of Entrepreneurs, I was skeptical. Legal, by some people's opinion, can be dry. And I didn't know how this session was going to go over. And it turns out at the end of the session, it was an overwhelming success. People were so enthusiastic to hear some answers from attorneys. They didn't know where to go with legal. And really, in my opinion, that's what attorneys are here for. They're here for the answers, right? A lot of times they're your closest advisor in a startup. So we've expanded this year. We've added additional panelists and additional topics, gone into 3 different areas of law. And it's important, I think it was, I don't remember if it was Dan or Kaz, I think it was Kaz, said to me that if there was a Venn diagram of law, right, like all the circles of all 3 of the attorneys overlap in places, right? They're all, they all practice a little bit of what each other do, right? So, but with that said, we're going to talk to these experts on things that are, probably, in their main wheelhouse. So Ted Howell from Howell Legal is with us. For all disclosure, Ted's actually the attorney for my startup. Like I said, I prefer to think of my attorney as a trusted partner and an advisor, and I think all these attorneys should be viewed that way. He's been known to all in the startup community here in Rhode Island. He's been practicing here in Rhode Island since 2003. I think, Ted, you've been practicing with startups since before 2000. And you opened your own firm here in 2014. You provide legal guidance in the area of contract negotiation, business formation, equity financing, technology transfer, and more. You're going to be talking today about the when and the why and the how to start with an attorney. And I'll get to that in just a minute. Let me introduce our other 2 panelists. Dan Holmander is chairman of the Intellectual Property Group at Adler, Pollock & Sheehan. He is an IP lawyer, a registered patent attorney, an intellectual property consultant, and a patent and trademark attorney, and will be speaking with us today. He has extensive experience in developing and executing honest and straightforward strategies for clients' intellectual property portfolios. And one of the things I find the most interesting about Dan is, if it's not enough that he's just a world-class IP lawyer, he happens to also be an adjunct professor of molecular pharmacology, physiology, and biotechnology at Brown. So super impressive, Dan. I didn't know that when we were talking before about you. It just blows me away.
My face turning red.
And then Kaz DiCavallo, who I had the great pleasure of meeting recently, and I swear I probably could have chatted for 20 minutes more with him just about life. It was really a great pleasure getting to know him. He's with Pannone, Lopes, Devereaux, and O'Gara, though I believe I'm allowed to call them PLD and O from now on. Kaz delivers specialized agile legal services, specializing in technology and artificial intelligence law, intellectual property and business ethics, and regulatory compliance. Today, he's going to be taking the mantle when it comes to M&A, which, when you're starting a startup, may not be at the top of your mind, but there's a couple of reasons why it probably should be. So we're going to go through all of these topics. Let's start with Ted, right? If we're going to start with a lawyer to start with, why not start with the conversation around startups? And that's where you're going to be, Ted. Great. So, I think you and I have talked about this many times. We could go off for an hour. We really have about 12 minutes per attorney here. When should you first engage with an attorney? I know I came to that moment, and when we sat down in July of 2015, right? And you and I have talked a lot about how people get involved with LegalZoom and the DIY, and then they make the mistakes that when you get to Kaz and the M&A stuff, come back to bite you. So talk to us about the when and the why and the how.
Yeah, so I mean, there are a lot of answers to this. The simplest answer is it's probably a good idea to be talking to a lawyer on day one. And I think it probably, well, I can definitely speak for Dan and Kaz and myself. Don't be afraid to come and talk to us. Don't be afraid that we're going to bill you for coming in and having a consultation. And you hit the nail on the head, Pat. The biggest problem, one of the biggest problems that we see with startups is in order to save a few pennies up front, when they don't have the dollars, they don't engage legal counsel, and they do things that just don't work well for startups. For instance, maybe they start their company as an S corporation, which Kaz will tell you is a no-no for a tech company that's looking to do an M&A, because they can't take advantage of certain areas of the tax code relating to capital gains. They may enter into or agree to give certain equity to co-founders, or they may do a number of things that we see them all the time. And I can't tell you, Pat, how many times a client will come in and they'll tell us, oh, well, we formed on, LegalZoom or Harvard Business Services. We paid X dollars, and now we're coming to you because we've got a bit more traction. And I look at what they paid, and they probably would have paid less coming to me, or to Kaz or to Dan, and they probably also would have done things right. And we certainly would have given them some ideas about where they could go to look to do things right, even if they weren't using us. So I will say in the corporate world, if you're looking, most importantly, if you have partners in your business, it's not just you alone, definitely come and speak to me. If you have specific intellectual property that you think might be patentable, go and talk to Dan. And the same may be true with a trademark. If in fact, you're going to be entering into contracts, or you're going to be having sort of an online presence, once again, come and talk to one of us. And likewise, if you're going to be looking into financing, bringing in people just as investors, absolutely come and talk to us. We're not going to charge you to come in, and we'll be honest with you and straight up with you about what your options are.
No, and I mean, oh my God, so many places I could go from everything you just said. Let me just rewind back to when you were just around the corner from here in the original office. I came to visit you, and we talked, and I had so many questions. As a founder, I'm not a lawyer, and I didn't understand why I might want to be a C Corp versus an LLC or whatever the case may be. And I remember you having a conversation with me about my plans to fundraise, and how if I was going to do certain things and take money in certain ways, it was better to be a C Corp sooner rather than spend the money on the LLC and have to convert within a year anyway. But even more from there, I think all of this is really daunting, right? There's convertible debt versus safes. What is equity investing? I didn't know how to read a cap table before I started doing this. So what are some of the most important things I think you would talk to a founder and help them get some early understanding with? I know there's some very young entrepreneurs out there, and they'd love to hear some of just the basic blocking and tackling that you can help with.
Yeah, so you already hit the nail on the head. One of the first questions that we will ask is how they plan to finance their company. Without going into crazy detail, if you're not a technology startup, and if you're not bringing in equity financing, there's a good chance that an S Corp is actually your best choice, which is the worst choice for a startup. And these are things that we can kind of tease out as we ask questions. But some of the other areas that we really typically see are situations where, maybe you have, 2 or 3 entrepreneurs that have an idea. They may even be students or graduate students. And they think, well, this is great. We're going to be, the next Mark Zuckerberg. And maybe they will be. But ultimately, what usually ends up happening in those circumstances is maybe they agree, hey, let's just split the equity a third, and we'll move forward. and they don't come and talk to a lawyer about it. And in fact, what ends up happening is maybe one of them gets an offer at Deloitte, and they go and they take that offer at Deloitte, and they say, well, hang on a second. I still agreed to a third, even though I'm going and taking this offer at Deloitte. That's still going to be something. I still want to have the equity. So we see fights start, right? So we're almost setting up it's like you might have a premarital agreement. We see this almost the same way, but in the corporate sense, right? So we're kind of assuming that you're going to break up, unfortunately, but we're putting the groundwork and the foundation in order to allow that to happen. And going to your point on the form of entity and sort of the LLC versus the corporation, and specifically your point on, why waste money on an LLC if we can go straight into a C Corp. There are very, very compelling reasons to go into an LLC. Usually those involve situations where either you have a single founder that are going into a single member LLC, which is quite simple, or you have a situation where the founders are putting a lot of their own money into the entity, and they can take some tax benefits by virtue of doing that. But ultimately, if they're a tech startup and they're getting outside financing, there's a 95% chance that they're going to end up in a C Corp. And so we always sort of look at it through that lens.
Yep. Again, I can't stress enough. I know I talk to a lot of young entrepreneurs and they're like, well, I can't go spend money on an attorney and I don't have money for an attorney. And I can say honestly that these gentlemen here on the screen, they're your closest advisors. Your attorney is almost that, non-equity partner in your business that is there to protect you from putting your foot in the bear trap. And even just going to have a cup of coffee or a phone call in the COVID era with someone just can help you in so many ways. So talking about putting your foot in the bear trap, yep. Ted, you want to tell us a couple of common, you don't have to tell us the big horror stories. Tell us the most common ones, the things that the people listening now should try to avoid.
Yeah. So there are a lot of them. In fact, I did a presentation about a week ago where I said, I tried to call it the 7 most common mistakes of startups, and I ended up with 9 of them, and I couldn't get it down smaller. But a lot of them are usually tax related. And a lot of them actually stem out of a misunderstanding of cap tables. You mentioned that you didn't know how to read a cap table beforehand. And a misunderstanding that issuing equity to stockholders is actually potentially a taxable event, and that there are all these things that we do to avoid that need to be done in order to avoid it. And so some of the biggest mistakes I've seen, one of them I already mentioned, it's forming as an S Corp, right? I can't harp on that one enough because it's very expensive to undo for a startup. And so that's one to stay away from. Another one is that I see often is agreeing to give someone a non-dilutable position in a company, or just saying, I'm going to give you, pick a number, 5% of the company, and with anti-dilution. Never give anti-dilution. There's, at least in that simplest sense, there are terms in investor agreements down the road that are called anti-dilution rights, but they're very different than what most people think. Nobody should be guaranteed a set percentage in the company. Another is be stingy with your equity. As you move forward, and you know this, Pat, as you move forward, as new people come in and new investors come in, it's like you're printing money. And, what happens when you print money? You have inflation. Well, that's essentially what's happening to existing shareholders. They're getting diluted by all that new printed stock. And it's very important to investors that the people on the cap table are people who are actively in the business. So don't grant somebody a big, 10% of the company based on what you hope they're going to do. And along those lines, make sure you have the right to get it back if they don't. So is that a good starting point, or should I go further?
Not only is it a great starting point, we only have about 3 minutes until I have to jump over to Dan.
Oh, okay.
So, yeah, I mean, a lot of great content there. Talk to me a little bit. I know this was one of the ones that was a big head scratcher for me. When it came time to incorporate, right?
Yeah.
You just looked at me matter-of-factly and said, you're going to be a Delaware Corp. You should be a Delaware Corp. And I said, but I want to be in Rhode Island. And you said, you can incorporate in Delaware. You're going to register in Rhode Island. And my head rolled around because I'm a product guy, not a lawyer. Can you talk to me a little bit about the differences and the reasons for some of this, and why certain businesses might want to be Delaware Corps?
Yeah, so absolutely. And I'll try to keep it brief. One fundamental thing that people need to understand is, if you're engaging in business within a certain state, you need to register your business in that state, which means you either have to form it there, or if you're formed in a different state like Delaware, you have to qualify it to do business there. And so there are people out there who will say things like, well, I want to form in Nevada because there's no income tax. And I shake my head and look at them and say, don't form in Nevada, because you're still going to qualify in Rhode Island if you're working in Rhode Island, and you're still going to have to pay your taxes in Rhode Island in your annual report. But now you're also going to have to pay an annual report fee in Nevada. And so you may ask me, why Delaware? Because the same concept applies. When you form in Delaware, you're subjecting yourself to annual reporting requirements in Delaware, franchise taxes in Delaware, and you're qualifying the business in Rhode Island because Rhode Island requires you to, just like every other state. And you're paying, the minimum taxes in Rhode Island as well as your annual report fees. So why would you do that? And the reason is, if you're a company that's on a fast track towards investment, investors like Delaware because of the law. It's not because of the taxes, it's because of the law. Most large companies in the United States have been formed in Delaware. And because of that, the Delaware law as it relates to corporations is very well settled. It's understandable. Investors know it, and that's what they're comfortable with. They don't want to get dragged into a court in Rhode Island and get hung up on some archaic or law in Rhode Island that's different than what they understand in Delaware. And so very quickly, if you're a startup, we recommend a lot of times going straight to Delaware. There are those who can form in Rhode Island first and then convert to Delaware. And that may make sense if they're not looking for investment for several years down the road, because they can at least save on those taxes, those franchise taxes in Delaware for a period of time.
Great. And, I could go on. I think so many people need to learn about anti-dilution and why that's somewhat normal, and then what to look out for, like participating preferred, and so many of those things. We could go on a whole hour of really deep, rich learnings that I've had just from doing this, doing my startup, and all the things I didn't know 5 years ago. But now I'd like to just take to thank you. We're going to have questions for Ted. We're going to hold all the questions off to the end of the session. I'm going to move on to Dan. Dan, you're going to tell us about IP, which, for those, there are a handful of people out there who don't think of IP, what it stands for. It's intellectual property, right? And maybe even for some of the uninitiative, just a broad definition of what constitutes intellectual property. Because I found several young founders who were great engineers, but didn't actually understand that true definition of IP.
Thanks, Pat, and thanks for inviting us to the panel today. Before I get started on IP, I just want to say it's an honor to be on a panel with Ted and Kaz. I can say unequivocally, you're looking at two of the best attorneys at the peak of their careers in this space, and I unequivocally think they have the highest integrity in this field. So I just wanted to say that before we get started, because I think that is an absolutely essential ingredient to selecting a good attorney. When it comes to intellectual property, so like Ted, I mean, this is quite a story, quite a bit. But let's just talk about one of the common myths about what IP is, intellectual property. People think typically their knee-jerk reaction is the word patents, and it kind of stays there, and that doesn't go any further. But you really have to think a more holistic approach about what intellectual property is. Intellectual property is patents, but it's trademarks, it's copyrights, it's trade dress, it's trade secrets. Those are kind of the major buckets that you should be thinking about when you think of intellectual property. And each one of those rights has its own set of rules and its own set of both benefits and constraints. And when you're thinking about intellectual property, especially as an early stage company, the first thing you should be thinking about is, what is my intellectual property strategy? A strategy is not filing a patent, okay? It is not doing necessarily any action whatsoever when it comes to intellectual property rights. What it is actually, it's a document that I think oftentimes, if it's not included, should be included in your business plan. And what you're looking to do is align your business goals with your intellectual property strategy. Easier said than done, because there's a lot of what intellectual property is, a little bit of a prediction of the future of where the company might pivot or might migrate in the future. So your intellectual property strategy is not a one-time event at the beginning of the formation of your company. It's a living and breathing process. And it's almost a philosophy of how you're going to use intellectual property rights in those buckets that I identified in a way that's going to give you a competitive advantage in the marketplace.
So, Dan, and first of all, before I forget, if it sounds like Dan could teach a class on this, it's because he does, okay?
Yeah. Sorry.
So that said, I think one of the things that happens to a lot of founders is they get all hyped up and, you go out there, you get your trademark. I got my trademark. Part of getting my trademark was finding a URL first, right? It's almost like you find the URL first. It's harder to find the URL than to find something you can trademark these days. But I found my URL, I got my trademark. That's all great. And then you're thinking, all right, I'm going to go for a patent. I actually believe I've got a non-provisional patent opportunity here. And then the reality of that sets in, that pulling people off of work to document and do all that work is a ton of work. There's cost involved. And I feel sometimes there's just so many startups who miss an opportunity to go for a patent. I think I missed an opportunity to go for a patent. I may have a mea culpa on that one myself when I was dealing with, not you, a different patent and trademark attorney. And it was probably because I didn't understand enough. Why don't you talk to us a little bit? We had a great conversation the other day around, where do you start? How do you start? How do you start small and digestible and get some protection?
Yeah, so, again, I think when I talked about, this dovetails what I was talking about IP strategy, right? So what are the factors in that, and how do you get started? So the first thing is you have to identify where you're at. And I've got, Ted was talking about how he couldn't whittle his list down to, 9 different things you shouldn't do, but I have a list, I got it down to 8, so I'm doing okay here. But basically, in order to decide what your next step is, whether it's a patent, trademark, et cetera, I think you have to identify first these 8 tranches. One is, what is the technology space that you're in, okay? That's a huge influence over what you're going to do. Life science, biotech versus software, mechanical, electrical. There's a lot of different things, and how you're going to compete in that space. Public disclosure. Are you about to imminently disclose your invention? One of the things that people make a mistake on quite a bit is they disclose their invention, and that act actually will destroy your rights in terms of acquiring a patent, and you need to be aware of that. So your timing in terms of your public disclosures. What capital stage are you at? Okay, do you have the money? There's this tension, I think Ted alluded to this, where you're in an early stage, which is really probably a time when IP becomes actually probably more important, but yet this is a time when you have less money to spend on it. So what capital stage are you at, and what can you do now, and what do you have to put off in the future? The regulatory environment, the FDA and other regulatory bodies, how is that going to influence your IP strategy? the strength and quality of the patent. It's not about whether you can get a patent, it's about what is the patent going to do for you when you receive it. The types of patents, Pat, you talked about provisional, non-provisional, design patents, plant patents. Again, it all depends on the technology, and it depends on what the strength and quality of that patent is going to be. Foreign protection, whether you're going to file in the United States and other countries, and enforceability of the patent. Is it an apparatus? Is it a thing? Is it a method? How enforceable will it be at the end? Those are the questions that you need to start with. And then when you answer those questions, that will translate into what I call tactics, which is now I need to file a patent, now I need to file a trademark, now I need to file a copyright, et cetera. But that's the second step from that.
Okay. And you mentioned international, and this is something I still can't get my head completely around, or haven't perfectly got my head around, but there is a counter that starts when you do an action in one country that sets off a timer to take action everywhere else, right? That's a big part of the decision? Yeah,
so timing, again, big part of your intellectual property strategy is the timing of your filing. So I'll give an example. You think you have a new invention. It's not a working prototype. It's at a stage where it's not quite working. It hasn't been fully enabled. If you file a provisional application on that, you're putting yourself on a shot clock of 12 months that at the end, typically you would file a non-provisional application. And also, you might have to file foreign as well, oftentimes a PCT application, which will give you a placeholder in over 200 countries. Maybe you want to hold off on filing that provisional. If you don't have an imminent public disclosure, then you may be able to wait until it's proper time. That's also a way, going back to early stage companies, they may not want to even spend the money on a provisional. If you're not going to disclose your invention, you can use CDAs and non-disclosure agreements to protect yourself, and then maybe later on file a patent application, okay? But oftentimes people will go, I need to file a patent, I heard it's first to file, I need to be first. That may actually be a mistake, because you may actually be rushing to spend money that you don't have. And when I call you in 12 months and say, hey, now we have to take a more advanced step in this process and start thinking about foreign protection and non-provisionals, and you're like, I'm not even there yet. I don't have the budget to even think about that. So the timing of how you sequence these events is absolutely critical.
And that goes back to your point about having a strategy.
Yes.
Absolutely. So I started, and for all disclosure, when I originally started, I wasn't going to do my startup here in Rhode Island. I was going to do it in California. And my original attorney that I was working with that got me my trademark is not one of the ones who's on the call. It was a California-based attorney, so I'm not hanging any of the negative mistakes I've said or am about to say about myself on anyone on this call. I wish I had done everything from the start, right, with the brain trust that's here. When I was early in that conversation, like I said, we sat there and we talked about the amount of documentation, and there was $3,500 or $4,000 for this or for that, and it just all seemed so daunting. Mm-hmm. In retrospect, I had wished in that early day, before there was public disclosure, before I did any of that stuff, that I had taken that step, possibly even before, right at the point of incorporation or before incorporation, to do that documentation so early on. And again, predates everyone here, but, woulda, shoulda, coulda. You actually had said to me, to get in the game, you don't need to actually start the process at $4,000 or thousands of dollars. It's actually a much lower number just to get on the books. Explain. Yeah,
so, and I'm sorry what happened to you in California. I apologize. I don't know what happened there with that person.
Southern California, we're not going to go into it.
So I used to teach a class called you can get a patent, a trademark, a copyright, and a trade secret for $75. Okay, back then it was $60, now it's $75. How do you do that? Well, what you have to understand is that there's 3 of those 4 require no affirmative acts with the government authority. Okay, so what Pat's describing is he had an idea for a trademark, and oftentimes early stage companies, that's something that you can wait on. Okay, you have a thing called common law trademark rights, and you definitely want to make sure that you have the right to use it. Going back to Pat's example of, can you use it? Is there a domain name available? Handles on social media, et cetera. But if it's available for use, You can build your rights on a common law basis. You don't need to go rush and file a federal trademark application. Copyrights from the moment of creation, whether that's a source code for software, that's an unregistered copyright. That actually doesn't need to be registered immediately. Again, no cost, just identify it, and you now have that right. So you have a copyright, you have a trademark, no cost so far. Trade secrets, it's about understanding what information you have is considered a trade secret. Not all information is actually created equal. Some of that information has economic value to the company, some of it doesn't. And segregating that into those tranches is absolutely critical, and then protecting it, okay? That doesn't cost you. This is all just homework, okay? The one thing that actually costs you the $75 is a microentity provisional application, okay? And that's the government fee. And I'm not going to bash LegalZoom or going directly to the USPTO, because there are certain, I'll call them mechanical, low complex inventions that may, if you have sufficient drawings, may lend themselves to an DIY filing, okay? But that's where the $75 comes in. And the idea is that as a early stage company, if you have a budget, that has to dovetail into your strategy. If you only have $75, then that's what you need to do, okay? But the idea of saying, well, I don't have any money, therefore I can't do anything, that's not the right answer.
So you and we got a couple more minutes. I shared with you a story. I originally had a different name for my business. I was sitting in a Starbucks on California Street in San Francisco, across the street from the Oracle office, when I got a call from that other prior attorney who advised me, and this was good advice. He said, you can't use that name. Somebody else has not only the rights to it, but they're, in my opinion, way too close to what you're looking to do. And I suspect that you could be sued. Now, the other half of my story was sitting in the Starbucks. I looked at the barista behind the counter and got inspired and saw that they didn't make the coffee or grind the coffee or grow the coffee or package or ship or flavor or any of it. They put the coffee in the cup, and they were the last mile of the coffee delivery. And I'm the last mile of data delivery. So I was a data barista or data-rista, and thus I was off with my name. You and I, though, talked that probably one of the most common mistakes is people they go online, they do some quick online check for a trademark. They make some self-determination that they're okay based on what they can find. And by the time they get the cause at the end of the trail, there could be big trouble.
Yeah, I mean, first of all, what you did was a nice a strategy, actually. Okay, what you created in your brand was we call a fanciful name or a made-up name. And if it's that fanciful or completely made up, the likelihood that somebody else is actually using it is very small, right? But the tendency is a lot of people want to tell you, be very descriptive or generic about what they're doing because they want the consumers to know, this is what I'm doing. But from a legal standpoint, that's the opposite of what you want to do, okay? So there's somewhere between fanciful and descriptive and generic is where you want to be. And you can save a lot of money and time and grief by checking the U.S. Trademark Office database, checking the state databases, checking Google domain names. If you tried 16 times to get a domain name and you still haven't succeeded, and I'm not even saying 16 is the limit, it should be even earlier than that, there should be a thought in your head that maybe this might not be the trademark I should use, okay? When you see somebody organically and you say, well, they don't seem sophisticated, or they're in Iowa, or I really don't, seems like they're not doing exactly what I'm doing. They're doing something related but not quite different. Recognize that the likelihood of confusion is broader than that. So the advantage you have as an early stage company is to get it right the first time and not have to deal with that either embarrassing letter or embarrassing moment where you have to go back to somebody and say, hey, you know that company I've been telling you about for 2 years to invest in, we're now a different company name. It's like putting the mud on the tires of a beautiful car.
Yep. So Dan, you and I, we had a call earlier in the week. We wound up talking for close to an hour about what we would say in a 15-minute session. This could be, just like Ted could be his own session on the formation part. And I swear I could talk for an hour to Ted. I could talk to an hour for you on the IP stuff. But to be fair, We have Kaz up here, or at least on my screen, he's over here. On your screen, he could be somewhere else. But Kaz is joining us, and he's going to be talking about M&A. And for a lot of people in that audience who haven't even started yet, or are just forming, or they haven't even taken seed capital yet, they're thinking, why am I thinking M&A now? Okay, Kaz, why are they thinking M&A now?
All right. Well, hi, everybody. How are you? And I'm delighted to be here. I also want to echo Dan's thoughts. It's so nice to be involved on a panel with two other professionals that I have such high respect for. Not only is there a Venn diagram in terms of what we all do and a fair amount of overlap, but we actually all work together, fairly frequently. Based on the nature of what I do, I probably interact with Dan more than with Ted, but I don't think you can overstate the degree to which, though, I want to underline something Ted said early on, which is having a conversation with a good attorney from day one. You probably can't be overstated, and that is often before I get involved in a client relationship because of the nature of what I do. But Ted also mentioned LegalZoom. I get a fair number of clients every year who come to me because they did LegalZoom, and I'm not throwing LegalZoom under the bus. LegalZoom is a fantastic resource if you know exactly what you're looking for and what you're trying to accomplish. The problem is that there are so many materials on LegalZoom and similar sites that if you don't know what you're trying to do, you can really screw it up. And look, I don't, this is not a scare tactic. There are not so many things that at the end of the day we can't fix, right? But me having to fix it invariably is more expensive and time consuming than if we did it right the first time. I think, my colleagues will agree with this. And so that, if that's me or Ted or Dan giving you, an hour of our time, just to kind of get you on the right track, I cannot tell you, you will be well served with that initial discussion. So, all right, I am probably going to start this even a little bit before the M&A space, because as a practical matter, it is one thing to have a startup and to start a business, right? And Ted's a master at this. I literally had a fairly long discussion back and forth. Ted, within the last year or so, Ted was giving me his thoughts on his particular preferences about C corporations versus LLCs, and it's great. I've been an attorney. Actually, we're almost exact peers. I've been an attorney a little over 20 years, and I was learning stuff. It was great about investor preferences and some of the specific tax things that they're looking for and their target investments. And it was a fantastic conversation. But it's a completely different thing or a separate thing to run a business, right? Startup versus actual operating and going forward. And look, in this space, and particularly in this venue, I think it's fair to say that most startups, you have this halcyon vision that you're going to have an early funding event or IPO or whatever. And there's nothing wrong with that, right? A ship tends to go where you point it, so that's great. But the reality is that it's a minority of companies that actually get that early event. And these are viable concepts, viable companies. And there's a lot that you can be doing, though, between a startup and what you might have thought was an early event, and then running that business efficiently and effectively and with a great strategy is far more likely to get you to that end goal at the end of the day, if it's delayed. Because the reality is that nobody has a crystal ball. We can't know. We can put you, in the driver's seat in terms of best strategies for you to have as much flexibility as you can to maybe pick that event that was unforeseen. So along the way, potentially to an M&A place, and I'm going to hold that off for just a second. There are all kinds of things that could come up. Dan mentioned having an effective IP strategy. Certainly, there are some things you can do early on to really screw up your patent rights. It just makes something unpatentable if you divulge, right? But here's another one. lots and lots of companies develop additional IP as they go along. And I've seen some situations where some clients were relying on their early patent filing for protection, where some of the things they were developing and using, and in a couple of cases divulging, weren't protected by that patent. So Dan may not be standing over your shoulder the whole time, every day and having a conversation with him, but someone like me or someone like Ted really should be able to guide you and say, hey, wait a second. This is a point where maybe we should give Dan a call because I think there might be some additional patent rights here. Other things that could happen. Ted mentioned another one. What if one of your partners leaves? Okay, you gave your partner equity, and a year later they go off because they want to do another startup, or they get picked up by some company or whatever. Well, you've given them equity in your company. What's going to happen? Are they going to go off to Oregon or Tibet and just be a ride along 20% shareholder of your company until the end of time? Or maybe did you put some decent clawback rights into your starting document so that you can do something about just that? Some viable buy-sell provisions where you can actually get a partner out. What if your partner's an asshole? That's a legal term. What can you do? You can use a nicer term. What if you have an aggressive activist shareholder in your company? That's a nice way to put it. Is there anything you can do about that? Here's one I see periodically. It depends on the situation, but we get husband and wife teams, or husband, wife, whatever, spouses who start a company, run it for 2 years, and then they don't get along. And so you have two parties divorcing. What happens? They hate each other. Do they keep running a business? That I don't do any family law, but it's not uncommon for me to advise my clients together and refer them each separately to their own divorce attorneys, with my standing goal being to find divorce attorneys that work well together. That's for the client's benefit on both sides. What else? So making sure you are in fact protecting all of your IP rights, not just your patent stuff. You may have patents, you may have trademarks, you may have trademark filings, you may have things that are not technically registered and stay in that trade secret space. Are you using good NDA forms? Another example of LegalZoom or Google, you can pull 1 million types of NDA agreements off of the internet, right? Here's an issue very few people don't really think about in terms of thinking forward. If I have you sign a document where you promise that you are not going to divulge what I tell you, fantastic, okay? That's not going to be an issue in 2 weeks. It's going to be an issue in 2 years. And 2 years later, I have to try and figure out, okay, yeah, here's this document you signed. What did I tell you? And they say to you, well, you didn't tell me that. You didn't divulge that to me. Well, yes, I did. No, I didn't. Okay. So the trick there is you can't hand someone an NDA and say, and write what you're divulging in the NDA, because what if they don't sign it? So, all kinds of sort of little strategies that you may just sort of run into along the way. So what I do perhaps more than Ted and Dan, who I would say really are true specialists in their respective fields, I'm a quarterback. My job is to figure out those issues as they come along, and if it's something that I handle, I'm an M&A specialist, great. If not, I'll be the first person on the phone to reach out to one of these guys and tell you this is who we need to talk to, because that's what they do. Now, that takes us to the M&A space. People hear the word, acquisition, and they think, well, that's one of the things that I want to do. I want to be acquired at some point. Okay, great. That's an M&A transaction. But what if it turns out that your company is a really successful ongoing venture, and you run into a situation where suddenly you're in a position to buy other companies, maybe rolling these things up, you're spinning out franchises or whatever. These are the kinds of things that are very much in my wheelhouse. And again, that may not be something that you have on your radar at all from day one, but there are certainly effective strategies that we can put in place in early stages of a company to make those sorts of opportunities the better potential for you to be in the best possible space you can be 12, 18, 24, 36 months. And that's what we're trying to do.
Kaz, that's actually one of the things I was going to point out. You talk about, I've been a CEO, I've been running a business for over 5 years, 5.5 years. And, I think as all startups, we think of M&A, we're thinking about an exit. I'm going to get that check. I'm going to, you're always thinking about that, right? That's always what's the foremost in your mind. And I said to you, when I spoke to you, I said, you're going to talk about M&A. He said, great. Are you talking about buying or selling? And it just stopped me in my tracks for a split second. In 5.5 years, I never even contemplated the fact that at some point my business might acquire somebody, right? It never even was in the early plans. And it's such a simple concept. And man, just something to be thinking about early on. Another thing, I'm sure you have tons of horror stories, and we probably have about 4 minutes till we're going to get to some of the Q&A. I've been super meticulous in trying to keep organized and keep track of, PIAAs. For those of you out there who don't know what a PIAA is, it's a proprietary information and assignment agreement. It's what you give your employees that basically says everything they make while working for you is yours, right? That's what Kaz was referring to before. And I've got MSAs and I've got NDAs, and you can pick any 3 letters. I probably have one of those. I have been super meticulous, knowing that one day when I get to the end of that trail, having that stuff organized is probably going to save a ton of time, a ton of legal expense in the exit. And if you're not prepared, that when it comes time for due diligence, a guy like you, Kaz, and your team are just going to have to become business forensic scientists trying to figure out the what and the where.
Forensic is exactly right. Yeah, that's right. So, what I would say to that is the good news is I see less issues in this space now than I did 15 or 20 years ago. The rationale is that so many of these documents that we have are flying back and forth in electronic form. There's a trail somewhere. But I'll give you an example of something that one of my early career situations that happened, which is a good example of what we're trying to avoid here. This happened to be a relatively small deal. It was $2.5–3 million, and it was a multi-generational family business that was being sold. Okay, so an acquirer came in. There was a purchase and sale agreement. A deal was made. They got to a number, and suddenly we got to the representations and warranties, which one of the baseline representations in an M&A deal is that the seller is saying, yes, we can assure you that we are giving you 100% of the equity of this company. Whatever you're buying, we have the right to sell it. That's when we got into the weeds, because as it turns out, this company had been operated for long enough in the family, and no one could quite remember who gave Cousin Vinny shares or Grandma Nettie. And there were literally some notes we found in like an old family Bible. It was, and they just didn't know. And it was 1%, 0.5%, whatever. But if you blow a representation in a purchase and sale agreement, that's dangerous territory, right? The point. It took me and 3 or 4 other young attorneys just like me weeks to go through all of this, family paper, the Bible I'm talking about, to figure out exactly what that was. And suddenly that $2.5 million acquisition became more like 1.8 because we spent hundreds of thousands of dollars in attorney time just trying to figure out who owned it. Now that's a horror story, right? I mean, that's not bad. But the point is if you get into one of these situations, Pat, you mentioned the magic words, due diligence. Particularly if you're selling or buying a company, you go to buy a company, you want to make sure you know exactly what all their contracts are. So somebody's going to have to go in and find those. And if that's something that you can do by saying, poof, here's our files, right? That's a 20-minute exercise. When you can't do that, that's maybe not a 20-minute exercise. That's days. And, in my world, you want to prove the old adage that time is money, talk to a corporate lawyer.
One last question. We're going to try to wrap here. Having things, we talked about having things like PIAAs and NDAs and other things in place. Commercial contracts, right? When it comes to things like change of control, et cetera. Are you seeing that a lot of these things are being put together early on by a great attorney who's putting the right wording in, or are people coming at you with contracts that don't really talk about what happens to the customers and obligations in a change of control?
Yeah, that's a broad question, Pat. So I guess my least favorite is when there's no contract. There are many ways that you can get into a perfectly binding legal agreement with a handshake. That's legal in most cases. But you can't ever prove who said what, and people's memories are notoriously fickle and almost always not. People aren't trying to do the wrong thing, but when you're trying to recollect something 2, 3, 5 years ago, people tend to have their own best interests in mind, and things get really screwy. A second stage of that is when you have a contract that is not clear, that's vague, that the provisions aren't well drafted at all. That is supposed to be our core skill set, particularly as business attorneys, is drafting agreement. All that weird language you hear about with the wherefores and the thou shalt, that's actually not necessary. We don't have to use that language. But the reason that language developed is because there is a skill set that is specific to drafting a document so that it can only be interpreted in exactly the one way that the people who got into that deal meant to do it in the first place. What separates the wheat from the chaff, though, is those of us who do this for a living will from time to time insert wiggle room where we need it on our clients' behalves. That's a whole other level of legal drafting. So, what can I tell you? My number one rule is put everything in writing. I literally advise my clients to follow up with phone calls, with an email saying, "Dear Jane, so glad we spoke about X, Y, and Z. Thanks, have a nice day." So that there's a trail of that down the road, that the call was made, and presumably if the person doesn't even respond to the email, you can at least argue, well, if she'd objected to what I said, she would have responded. Everything in writing. Obviously, if you have a good suite of documents, there are NDAs. I just mentioned a few minutes ago, there are NDAs and there are NDAs. I personally think you are well served by speaking with someone who knows what they're doing so that you have a good raft of documents. Now, the 2 quick points here. One of the wonderful things about my work is that every new client that I get, every client is unique. The personalities are unique, the concepts are unique, the types of businesses are unique, and I find that fascinating because I'm learning constantly. But there is a whole universe of things, contracts, types of issues that I've seen for decades, and they do tend to be relatively the same, identical, or very similar from company to company, where I've had the experience of how to get through and solve that problem that would be totally new to most startup business people. You just haven't seen it. So that's one of the advantages that I think we bring to the table. That's all of us. That's across what all of the panelists do. The last point I wanted to make, though, is that none of us get it right all the time. As a practitioner, I always struggle with the balance between wanting to spend 50 hours on every document to make sure it's perfect, but having to be able to justify to my client at the end of the year that what they paid me in fees is worth it. And so I can't spend, all of the review time that I would love to spend on each and every document. And at some point, the deals are coming quickly. You all want the product quickly. You need, you need it. I understand that. Fortunately, I have a body of experience and my own contracts to draw from. I know what to look for. And perhaps even more fortunately, or the cautionary note, the vast majority of these agreements, no one will ever look at again. I will be the first person to tell you, you will pay me for documents that I'm drafting for you that no one will ever look at again. Why? Because in the 0.1% that people do go back and look at those contracts, is because there's a problem. And someone like me, that's the point where they'll be going into that document and second guessing the placement of every single comma. And somewhere in the balance of that is how we provide the service to you. We try to get it right.
Excellent. Thank you, Kaz. And it's funny, you talked about the where-tos and legal language. And I don't know if Ted remembers this conversation, but we had coffee at Olga's Cup and Saucer right over here. And I actually called him out on that. And he said, well, Pat, you're a sailor. Why do you use port and starboard and helm, right? You have specific language in sailing about sheets and aft to not have confusion with other terms. When you say helm's a lee, duck, right, you know exactly what's happening because it's specifically worded language. It's not right as in correct or right as in right turn, right? It's always going to be, you know, port and starboard are going to be port and starboard without any confusion. There's no port wine on the boat. So I get your point. It's very well taken. Annette, I know that there have been a bunch of questions in the chat. I see a lot of our experts have been answering the questions in line in the chat. We're right up against the end of our time. Are there any unanswered questions?
I don't see any unanswered questions, actually. So if you have a question and for you it's not true, it looks like Ted did a lot of good answering here. Thank you, Ted. About forming a Delaware company keep us from qualifying for Rhode Island grants. No, it does not. If you're online doing business nationally, where would you register? And the good answer to that is basically wherever it is that you're doing business. So if you're doing the work for that entity, if you are at home in Rhode Island coding, then you are doing business in Rhode Island. So those are really the kind of the big questions.